Hi, haven't seen you today. Okay.
Special council,
I better do that, can't forget that. Okay.
special council workshop meeting, Monday, November 15th, 2021, 6 p.m. Heidrich.
Here.
Holtmeyer.
Here.
Patke.
Here.
Pettit.
Here.
Reed.
Here.
Scornia. Solentrip.
Here.
Wessels.
Aye.
Please rise for the Pledge of Allegiance.
Under God, indivisible, with liberty and justice for all.
Presentations, Employee Handbook.
Mayor, I'll go ahead and for the interest of time, because we've got a lot of material to cover for the workshop, and we hope we can go ahead and get through it. But just to give you, there's a letter that Sean and I signed for you, kind of giving you a little bit of a history of how we've gotten here and some of the highlights that we're going to have. Christy Coleman is here with Sandberg and Phoenix. I'm going to have her come up and go over some of the proposed changes that we have. We started this process probably 2 to 3 years ago. Sean and I started meeting because we saw some things within our the personnel manual that needed to be changed. There was references to some things that were outdated, and probably it has been a while since we've had that portion of our manual reviewed. In 2003.
Last we saw was 2003
When a policy was changed or whatever. So there's a lot has happened, and it was well overdue. So we started, Sean and I started looking at it with some changes that we had heard. We had requested from department heads. Then we met with department heads to go over this for approximately 8 months. I don't know. It was excruciating. I will say it was a long time, because there's a lot of long discussions. I say that in jest. It was, but there was a lot of discussions that took place with regards to that. And so, and then once we received all the comments back and had gone through the document, we passed it on to our legal counsel. Christy got done with it about a month or so ago. Yeah, and so, and she had a lot of changes with regards to it and had a lot of questions as to why it was set up. So what I've tried to do, Shauna and I tried to cover just some of the highlights that are a little bit different from the stuff that's in there, but Christy will be able to go into much more depth tonight. So with that, I'll turn it over to Christy.
Good evening, everyone. Thank you for having me here. My name is Christy Coleman, and I am a labor and employment attorney. I work with Mark, and I've been practicing for about 20 years, representing exclusively management. And one of the things that I do as labor and employment litigator is I try to make sure that my clients have the best possible handbooks and policies and procedures in place, try to prevent litigation. You're never going to prevent all litigation, but the idea there is that in the event that you do wind up getting sued by one of your employees, that you have everything that you need in your handbook and your manuals in place to try to help protect you. So some of the highlights of the things that we've done, first of all, your handbook was excruciatingly long. It was probably about 50 pages longer than what it needed to be. A lot of times what happens is that whenever you have handbooks that are that long and you're throwing everything but the kitchen sink in them, the managers don't always read what's in them. However, whenever you get to be a defendant in a lawsuit, the handbook is marked with an exhibit sticker, and it's assumed that if you've passed the handbook, that everybody that's a manager knows everything that's in it and they apply it. And so that's one of the reasons why you want to make sure that you have what you need in your handbook and nothing more. We also went through and made sure that where there was some room for some discretion, some management discretion, we wanted to make sure that we kept that discretion in order to make sure that the departments were managed effectively by the various department heads. But we also wanted to provide a certain layer above that with your human resources department to make sure that things were implemented in a fair and fairly consistent way. You don't want things to be implemented in favor of, for example, all male employees in this department over here, but the female employees over here don't receive those same benefits. You want to make sure that things are very consistent, especially where it comes to matters of race, sex, religion, national origin, those types of things. Some parts of your handbook were also very outdated. For example, we had some recent case law come out of the United States Supreme Court that extended sex discrimination protections to gender identity and sexual orientation. So we went ahead and included those as being protected classes within your handbook as well. We refined your grievance procedure that you have in the manual to be that if there's a violation of policy, any policy that's in that handbook, there is a structured grievance procedure. It's multiple layers, and you're the final stop on that. So, for example, whenever we have somebody that believes that they've been discriminated against on the basis of their sex, they're first to go to their supervisor, try to talk it out, and then they can file a complaint with HR. HR will investigate it. If the employee doesn't like the result of that investigation, they can bring it to you. The reason for that multiple layers, there's a couple different reasons. It's to bring a new set of eyes each time it's looked at, right? To make sure that we didn't miss anything, to see if there's other perspectives that we may have overlooked whenever the complaint first came in. It's also to provide kind of those levels of protection at the various levels of a bureaucracy within a system. So the idea with that being that if you receive complaints from individual staff members, for example, you want to make sure that you're referring those complaints back to the employee's supervisor and back to HR so they can go through that proper chain. That provides you some insulation as a council to make sure that if you ever do receive a complaint in front of the council, it's the first time you're hearing any details about it so that you can sit together as a council and deliberate and decide what needs to be done. So I know that it's very tempting for employees that you run into at Schnucks or that you run into at the gas station to try to talk to you about things that are going on at work. And I understand that as elected officials, you very much want to be accessible. But please keep in mind that if you've got employees that are bringing complaints to you, those really do need to go through kind of the chain of command and work their way up from the bottom so that we can make sure that they're being consistently investigated and consistently resolved of. And if it needs to come to you, it will. And you can hear that it's like the final level of appeal. And if the employee has an issue that is also potentially the basis of a lawsuit for discrimination, the employee has options after you. But keep in mind, when we're talking about lawsuits based on those protected classes, your age, sex, race, national origin, religion, gender, those things, we have defenses that are available to us as an employer, provided that we have a policy in place for the employee to grieve those issues, and we have followed that policy, which means that if the employee has an issue, they need to start that complaint at the lowest level possible, work their way up to you in order to get that resolved. That allows us to take advantage of some of those defenses that we want to have in the event that we get sued in state or federal court. Any questions so far? If you have questions as I go, please just holler them out. I tend to talk pretty fast. Okay, so just to give you some ideas, some other changes that we've made kind of ministerially throughout the process, we did provide for additional time off for new hires. Previously, you had to be with us for a full year before you were able to start utilizing your vacation time. Now you're able to access 24 hours of your vacation time once you've been through an introductory period of 90 days. And I say introductory period as opposed to probationary period because if you call something a probationary period, then the assumption is that once they get through the probationary period, they have some other protections that they didn't have on day one. And as most of you know, in Missouri, we are an at-will employment state, which means that you can be hired or fired for any reason or no reason, with or without notice, as long as it's not for an illegal reason. So that is the employee that walks into you on day 9 and also the employee that you have on day 900. They are both at-will employees. Once they get through that first 90 days, the introductory period, we do want them to have some access to vacation time. We also have provided for the payout of unused compensatory time. So under both state and federal law, because we are a municipality, we can let employees earn comp time instead of paying them time and a half for their time worked over 40 in a work week. It helps save us some cash. It also gives the employee some flexibility on what they do with that additional time that they've earned out. However, federal law says that whenever an employee leaves with comp time on the books, you pay that out to them because it is time that they have worked and they have earned. You pay that out to them at whatever their final rate of pay is. So what you don't want to have happen is an employee earning comp time in year 1 and they stay with you for 5 years and they quit, and you've got the comp time sitting here from year 1 and it's valued at $12 an hour as opposed to what they were earning 5 years later, and you have to pay it out that 5 years later rate. So what we did is we changed that to be that your comp time, you'll be zeroed out at the end of every fiscal year, so that you would receive payment prior to getting your raise that you receive at the beginning of the subsequent fiscal year. We also have updated the personal appearance policy to allow for more flexibility within the departments. For example, we had some very in-depth discussions about tattoos, like what was acceptable, what was not. And a lot of that depends on where you work. You know, if you're interacting with the public, and, you know, in a face-to-face type of a situation, do we really want the employees to be able to be covered in face tattoos? Maybe not. But if, you know, compare and contrast that to a lot of times people now, like, they will have their wedding rings tattooed on their finger. Is that acceptable? You know, so we kind of left some of that discretion up to the department head to say, okay, what is it the employee is expected to do? And we just want to make sure that we're uniformly applying that. So, for example, we're not basing our decision on what the content of a tattoo is. It's more based on what the placement of a tattoo is, and what the interaction that the person has with the public. We also added in a new holiday. Federal holiday is Juneteenth. That was added in by the federal government. However, as it stands right now, that holiday is only recognized when it falls on a Monday through Friday. So we will recognize the holiday and give the employees the day off if it falls on Monday through Friday. If at some point that changes to be like some of our other holidays, like for example, Christmas, sometimes that's observed on Friday or Monday if it falls on a weekend, we can make that accommodation down the road. But right now, they will receive that new federal holiday because it is federally protected as long as it falls within Monday through Friday.
Is that how it was written, a Monday through Friday
Yes,
holiday? I mean,
yes.
that's from the federal, that wasn't a Missouri
Yes.
thing or
The
whatever?
federal government did change it for federal employees. So federal employees, if it falls on a weekend, they get it on Monday or Friday. But that's not for any other
Okay,
employees.
I wasn't aware of that, thank you.
We also updated your employee leave policies to include the newly constructed VESA leave, which is the Victims Economic Security and Safety Act, that provides for up to 2 weeks of leave for an employee who's either the victim of a sexual assault or domestic violence, or that they are helping to take care of someone who is a victim of domestic violence or sexual assault. We've updated those policies, including provisions of how you ask for the time off. That statute also allows for physical accommodations to be made. So, for example, it talks about how do we honor a restraining order. If we have an employee that comes to us with a restraining order, how do we help that employee enforce that restraining order? It can also require us to temporarily relocate the employee if they have a safety concern about where they're physically located at the facility. We may have to temporarily move them in order to make sure they are safe while they are with us. We also included the addition of bereavement time for taking that time off for immediate family, and we defined that immediate family to be consistent with what immediate family is under the Family Medical Leave Act. And we gave 2 personal leave days that replaced previous bonus days that were earned by not using sick time. So with those personal leave days, we have the discretion. The employee has to ask for them in advance so that we can make sure that we have the proper level of staffing. But those personal leave days can be taken for whatever reason they want, as long as we have the appropriate staffing here at the city. We've also restructured the vacation time, that now we have incremental vacation that gets employees through their 15th year of employment. Basically, once they reach 15 years and up, they've kind of capped out at what they're going to receive for vacation time.
Christy, I'm sorry. The leave days, are they still at the approval discretion of the manager of their direct leave?
The personal days, yes.
Yeah, okay, thank
yes. Let's see here. We also clarified that holiday is not to be used in place of vacation day so that employees can't double stack on a vacation day. We also changed it so that the employer can claw back vacation pay in the event that the employee uses vacation time but they haven't yet earned. For example, if you've got somebody that needs to take an extra day off but they haven't earned it and you want to be able to grant them the ability to do that, they can do that. But if they then leave you before they've earned that time, they owe you the value of that time back upon separation. And we also changed the policy to provide that sick leave can be used in 1-hour increments. That is in order to make the sick leave policy consistent with the Family Medical Leave Act that says that employees can use FMLA leave in the smallest amount of time that the employer allows employees to use time off, but it can be no smaller than 1-hour increments. We incorporated new rules on how to use sick leave, and we implemented a certification requirement that once an employee has been gone for 3 days, the employee is responsible to bring us back a medical certification excusing that absence. The same also holds if the employee has a suspicious pattern of absences. For example, every time there's a home Cardinals game, if the employee happens to be sick, we can ask the employee to bring us a medical certification verifying their absences, or if they always take off on a Monday or a Friday and they have blue flu every Friday or Monday, that gets a little bit suspicious, so we can ask for a medical certification. We do have the right to send the employee out for medical certification at any time that we want at our expense. So if we suspect that an employee is not capable of performing the essential functions of their job, we want to make sure that we're not having people work that are not safe to work, or if just frankly that their absences are concerning and we want to make sure that they're able to work, we have the ability to send the employee out for medical certification at our expense at any time. We did remove the pandemic-related provisions of the handbook. That's a separate policy that the city had passed whenever the FFCRA was in place to give employees access to additional paid time off under FMLA and the EFMLA. That expired on December 31st of last year, and we did not opt to renew that at our expense, so we went ahead and took that provision out of the handbook. We also removed provisions that the employee has those rights under federal or state law anyway. So for example, we didn't want to outline out what specific type of leave or how much time an employee got for voting leave, because that is run concurrent with state law. So we just simply said things like the employee will be granted voting leave pursuant to state law. And if the employee has a question about what that means, they can ask HR. But that helps to kind of condense and consolidate your handbook and make it a little bit more user-friendly. We also removed your professional dues payment provision, because if you have employees that want us to take deductions for anything, actually, we need to honor that. Under federal law, the employee just has to put that request for a deduction in writing, and we have to honor that. We also removed the COBRA provisions of the handbook, again, not because we're taking away those COBRA rights to a terminated employee, but because they have those rights regardless of whether or not we have them in the handbook. And those that took out about 4 pages of your handbook that most people see all that legalese and that jargon, they just kind of glaze over and they skip through it. So we reframed the first part of your employment restrictions section as by addressing the issue of ethics for employees, and we eliminated the redundant statements that you had in there that had additional anti-discrimination language. We referred the employee back to the anti-discrimination provisions that were in the handbook already. We also simplified and streamlined your wireless telecommunications usage policy and completely revamped your acceptable usage policy, which is the policy that governs employees' use of technology, including your equipment that you own or their equipment that they're using your Wi-Fi to access. Specified out that the employees have no reasonable expectation of privacy when they're using your equipment, so we can search that equipment at any time. Made it clear that we own that equipment, so we can take it. It's a privilege to use it. It's not a right. And then if an employee is using their personal equipment, but they're accessing it through your wireless communication system or your Wi-Fi networks, you do have the right to monitor that to make sure they're not sending inappropriate content or any other content that violates your policies here at the city. Any questions on that? Okay. We also reworked your drug and alcohol-free workplace policy to simplify that and streamline it. You had a lot of verbiage in your policy that, frankly, employees are never going to want to know or need to know, that talked about what a medical technician is going to look at if you send somebody in for a drug and alcohol test, like how that test is conducted, like what temperature of the urine needs to be, and frankly, no employee cares unless they're intending to use that information to try to cheat the test. You don't really want to give them a roadmap on how to cheat a drug and alcohol test. So we removed all that information, and we talked about incorporating the smoking and tobacco usage provisions that, according to state law now, you can't smoke on city property. So we did put that within the policy as well. And we added the odor of alcohol or marijuana as an example of something that could constitute reasonable suspicion for testing. Any employee that operates safety equipment, for example, if you've got groundskeepers or if you've got plumbers, most of your facilities people, those people are going to be considered safety-sensitive positions, and people in safety-sensitive positions can be tested randomly. So we included provisions on how we're going to basically establish how do we randomly test those people. But any employee can be tested if we have a reasonable suspicion to suspect that they are under the influence while here at work. We had lengthy discussions on the impact of medical marijuana on this policy, and basically wanted to establish that, hey, if we smell it on you, or you're glassy-eyed and you seem like you're stoned, that's going to constitute reasonable suspicion. And while you very well may have a medical card to use it at home, that doesn't give you the right to come to work under the influence of it. So we wanted to definitely clarify that. We did talk about some of the issues that may come up now that it's recreationally legal in Illinois, and considering how we're 50 minutes away from the river. So how do you handle employees that were recreationally using it? And we're going to look at that on a case-by-case basis to see whether or not the employee, whether or not it impacted their ability to work here. But especially for those safety-sensitive people, you want to make sure that you don't have them under the influence while they're here. We also added in the provision that if you have a medical marijuana card and you are actively using it pursuant to your prescription and you're in a safety-sensitive position, we have the right to reassign you to a non-safety sensitive position during the time that you have your prescription, to make sure that you're not coming to work under the influence and putting potentially your coworkers in danger. We also simplified your descriptions of the types of testing that you will use from 5 down to 2, being random testing and return to duty testing and follow-up testing. We had some extensive conversations about when it's okay to test someone that's an applicant. We talked about how once you have a tentative offer of employment on the table, then it's okay to go ahead and ask for a drug or alcohol test, just like it's okay to ask for a fitness for duty test. You want to make sure that somebody can physically do the essential functions of the job with or without a reasonable accommodation. And we also added in that the employee has the option to meet with EAP, the EAP program that you have through the city, after they have one positive alcohol result, as opposed to the prior policy that said you had to have a continuing pattern of alcohol-related issues. Well, what's a continuing pattern? We wanted to take some of that subjectivity out. So basically, if the employee pops up as being under the influence of alcohol, they have basically a last chance option available to them that they could utilize your employee assistance program to receive drug and alcohol treatment and therapy so they can go ahead and keep their job, but they have to abide by the terms and conditions of whatever the EAP doctor outlines for them in order to maintain their position. And then once they come off of that EAP program, they have to be retested before they can come back to work without any type of last chance agreement. We also clarified that we have the right to discipline employees for violating our policy, and we eliminated other terms about rehabilitation and subsequent positive screening and for purposes of simplicity, and just kind of making sure those things were streamlined. On your safety rules and regulations, we removed the statement that department directors would develop and effect a reasonable motor vehicle preventative maintenance program, because not all of your employees utilize your vehicles. So basically, we decided to create a separate vehicle policy that if an employee is issued a city vehicle, that they would sign off on the policy that talks about maintaining all of your receipts, making sure that you abide by the speed limit, that you're not driving under the influence, that you're not texting while driving, all of those things. But not all of your employees are going to have access to vehicles, so it didn't make a whole lot of sense to keep that in the policy manual for everyone. On the workplace violence policy, we did streamline and simplify that by removing some general policy statements. And we also removed the city administrator from the immediate reporting structure for concerns about workplace violence. That needs to go directly to the Human Resources Office. Some other just kind of housekeeping changes that we made. We removed the policies on employee physical examinations, on the loss control policy statement and program, and the safety award. It provided us with some additional flexibility to be able to manage the employees depending on what their jobs are and what their department was. A lot of information. I know. Does anybody have any questions?
Was this already presented to the employees, or is this?
It's not been presented to the employees. We have gone through it with the department heads.
Okay.
We had a meeting with them on the 20th. So about 3 hours we met with them and made some changes kind of on the spot based on what some of their concerns were. And bear in mind that your police department, by the way, this policy manual acts as a gap filler for your police department. They have their own separate policies because they have other regulations and state statutes they have to comply with. So where those policies are silent, these will fill in those gaps. The next stage of the process is we're going to be reviewing your police department's employee manual as well.
Okay, thank you.
Mm-hmm.
Could you go back over the tattoo real quick?
Sure. Sure. So that's going to depend on what the department supervisor believes is to be reasonable. It can't be content-based. So, for example, if you have religious tattoos, we're not going to tell you that you can't have that tattoo just simply because it's based on the content. We could tell you that you can't have it because it's across your forehead, however. So it's going to depend on what the employee's position is, how much interaction they have with the public as well. And we wanted to make sure, we wanted to keep up with the time. You also don't want to cut yourself off from qualified applicants just simply because, they may have a hand tattoo. Now, I know that in some positions, like we talked with your police chief at length about that, and he doesn't want any visible tattoos, which is understandable. I mean, especially if you're out there interacting with children, as part of the community outreach, then you may not want that to be visible. However, if you've got somebody who's cutting the grass, does it really matter if they have a hand tattoo if they're qualified to do the position? Probably not. So we left that up to the discretion of the supervisor as long as it's not content-based.
So basically, I think it was anything from I think neck, face, those were, basically not allowed.
Right.
But the rest of them were up to the department head to go ahead and determine if they needed to be covered or
Right.
if they could be open. So,
We had
and
we
again,
had
a
some
lot of that
long-
has to do with their involvement with the public.
Right. We had a long conversation about the increased prevalence of tattooed rings. And especially when you have people that are working on heavy equipment, that seems to be more of a trend now, so that you don't have the safety issue of wearing a metal ring. So we wanted to make sure that if somebody came in and they had a tattooed ring, and they're not otherwise interacting with the public on a moment basis, that we don't disqualify them from employment because they have a tattooed wedding ring on their hand.
It'd be kind of tough to win a lawsuit under discrimination because of that handbook.
It would. But where tattoo policies really get you into trouble is where you do them on the basis of content. And I've defended employers who have tried to say, that you can't have Bible verses on your wrist, or that type of thing, or you can't have a cross on your hand. And the reason that it was denied is because of what it was, not from where it was. You're in a much better position if you say no because of where it is as opposed to what it is.
On your on the comp time, what are the parameters on comp time? How much time can you work in a week and put on to comp time?
It's capped based on the year, like how much time you can accumulate over the year. I think we came to 40. It's a rolling 40. So at any given time, you can't have any more than 40 hours of comp time on the books. So, and you don't start to accumulate comp time until you've already worked 40 in the work week, and it's by work week and not by day. So if I work, 8 hours and I work 10 hours and I work 6 hours, it all comes out to 40 hours in a work week. And it's actually timed worked. So that means you don't have to count their break times against that as well. So they can have that 40 hours of comp time, but they can't earn any more until they've started to use it, then it rolls off, then they can start accumulating back up again. So the most you're going to have as a payout is 40 hours at the end of the fiscal year.
Well, but what I was after was how much can a person work in a week?
They can work whatever you want them to work, but you just have to pay them. So you either have to pay them time and a half, or you have to pay them in comp
So
time.
you could work them 80 hours.
You could.
If you suspect somebody that's been drinking or on drugs, would you give them a breathalyzer, a blood test, or a hair test, or you don't want to divulge that?
Well, we would probably send them out to occupational medicine to have them be tested. That way, we don't actually conduct the tests ourselves. We want a degree of separation between us and that. So they're trained on how to conduct those tests and determine whether or not it needs to be in. Hair tests are not very common. It's usually a urine test. For alcohol, it's going to be breathalyzer. The difficulty with breathalyzer, of course, is it has to be the moment that you realize that they might be under the influence, because in an hour they could have metabolized it. It's a little bit easier if you're talking about being under the influence of narcotics, or being under the influence of marijuana. And on narcotics, by the way, we also changed your policy to include that if you have a prescription for a narcotic painkiller and you're taking the medication contrary to what the prescription is, either it's not your prescription and you're taking it, or you're taking it twice a day instead of once a day, that is considered to be illegal use of narcotics. So it's something that we would not only test you for, discipline for, but it may be something that we actually involve law enforcement in as well.
Would it be automatic if you were involved in a vehicle accident or an accident on the job?
Yes. Post-vehicle or post-accident testing is something that we have provided for in the handbook as well. And the reason for that is because you have the ability under the work comp system to receive a reduction. It's a penalty towards the employee, but it's a reduction in what your benefits would be if the employee was under the influence at the time of the accident.
And we do that now, Steve.
We do that now?
Yes.
Any accident is immediately drug test?
And as far as drug testing, who dictates, we do have a random drug testing, correct?
Correct.
Policy? Who dictates the random, who gets randomly?
We basically give them the names. We give occupational medicine the names, and they basically figure out what the order of those is going to be so that we don't control that. If we're going to the extent of picking out a particular employee that we want to be tested, it needs to be reasonably suspicion.
So this is something we do every month. There's a certain amount of people every month
No.
that gets a random drug test?
It was done quarterly before COVID.
Excuse me?
It was done quarterly before COVID. And it's not, we don't make the decision.
So before COVID, so now it's not getting
We
done?
have not had a provider to be on site, that's correct.
And the provider chooses the names.
We send the roster
A
Send a
roster.
roster,
they
they
pick the
pick the
people.
names.
Right, a roster of all employees.
that are eligible for random testing, yes.
And then they choose the names. We
Yes.
don't,
And everybody's in that? Everybody?
If they're eligible for random testing, so if they're in a safety-sensitive position, yes.
and those that are eligible are,
Should be every employee, correct?
It's not every employee, because not every employee is in a safety-sensitive position. A person who's a clerk, for example, they're just operating a computer, that's not a safety-sensitive position. But anybody who's operating heavy equipment, that's a safety-sensitive position. Any person who has a city vehicle is a safety-sensitive position, because they have your property that they're driving. But it's not everybody.
I would think every city employee should be on that.
It's a constitutional issue that you can't random test. They have a reasonable expectation of privacy unless you have an interest to protect in the safety of the equipment or the person.
But if you suspect a clerk is under the influence,
You send them
then
out.
that
That's a
sends out.
reasonable suspicion test, yes.
They're just not part of the random.
Right. Any other questions?
It doesn't make any sense to me.
Thank you very much.
thank you, Christy.
So with regards to moving forward, what we had envisioned was to go ahead and present an ordinance to you. It can be as early as the first meeting in December, or at minimum, the second meeting in December. We would like it for an effective date of January 1st, 2022.
Do we have?
So if we wanted anything changed in this handbook, we'd have to bring it up before December 6th.
We could, and that's why I think we've got the second meeting in December. If there's a lot of questions, we could try to answer those at the meeting on the 6th, and then we could go ahead and present you with the ordinance at the second meeting in December, which is December 20th. That's okay, Jeff.
Darren, do we have access to it? Are we?
Yes.
Yes.
Okay.
So,
So
yes, we have.
Shauna has copies for anybody that would like to see a copy of the manual. She's got those available. We just didn't want to print out a bunch of them in case you wanted to go ahead and see them. They are, or we can send them electronically as well.
So, do we want to disperse those, or let Shauna know what you want?
Just let Shauna know if you'd like a copy of that, and we will make sure and get it to you.
I would
I want to copy.
like an email, be fine with me. And
Okay?
Just pass them out to everybody on email.
I'll take mine in paper.
Joe wants his favorite too.
So, Mark, do you want
Since
to,
I'm not getting
let's go
you-
around so Shauna knows. So, Mark, what do you want? Email or paper?
He gave it to her. Mark's paper.
Email.
Mark's paper.
Email.
Email.
I want paper.
I would like paper too, in case I've got any notes I want to put down.
Both.
Just paper's fine.
Wessels, Pettit, and Fournier would like paper. Everyone else will get an email.
Read.
He said email.
You want to roll your own?
And then what is our timeline on?
If you'd like, well, it's up to, obviously, it's up to you as to when you really truly want to pass it. We would like to go ahead and have it done so that we could have an effective date of January 1st, 2022. So we've got 2 meetings in December. Or I'd entertain the option, if you want to hold a special meeting in December, to ask any questions of it. If you have a lot of questions that come up, I mean, then that's something that I would talk to Sean about if we need to go ahead and have a special session. Come on.
I'm talking to Mike. Just so you know why we're pushing for January 1, administratively, we'd like a nice clean start for this. A lot of the policies are calendar year and or fiscal year for next year, so we'd like a nice clean start to be able to start the new year with the new policies. That also gives us time after you approve it to kind of start rolling it out and work with administrative staff in payroll as well, because some of these policies, adding additional time will take a little bit of changing in our current payroll system. So that's why we'd like to get it rolled out in early January if possible, so we can stick to that calendar year.
Does the second meeting give you enough time?
It will. We've been working with staff, with the payroll staff and department heads, of course. And then the plan would be we would also meet with all payroll clerks that do the payroll in each department after this is approved, so that they're aware of the changes and how it works. It'll be a learning process like anything. Some people have been here a long, long time, and they've seen 4 or 5 policies through the years. So it will be a learning curve of, I thought the policy was, but we'll take the time to do education piece after the clerks. Then we'll do all employee training as well in some manner, whether that be coming in here, emails, mix of both, and then having sessions where people could come and ask questions.
Okay.
So I guess depending on what kind of responses we get, we'll determine whether it'll be at the first meeting or the second.
Correct.
For the sake of being here, I see almost every department head is here. Does anyone have any comments, positive or negative, on this that you could like to address that we may not see that affected your department?
The only comment I have for you is that said group of department heads met extensively with the city administrator and HR, and we drugged them over the coals over what you're seeing before you, and had a lot of discussion. And things that employees have asked for is in this. Most everything they've asked for is in this. You don't really need to go to the employees. What they've asked for is in that policy. So.
I do have a question. With it starting on January 1 in the middle of the fiscal year, are there financial implications for this fiscal year with any of the changes in terms of paying out? I mean, obviously, that would be next year.
That would be
but,
next year.
Yeah. Anything?
I'm not aware of anything. I don't know, Mary, do you have any? I'm not aware of anything.
Okay. Yeah. Great. Thank you.
What about the employees? Are they aware of this new handbook? And if they have any questions, how do they go about it?
If they have any questions about it, we can go ahead and send them the link to have that go out. I would imagine that there would be more questions about why are you doing this now? Why didn't you do this 10 years ago? Or why didn't you do this 5 years ago? And it'd be the fact of, well, I didn't get this at that point, you know, et cetera. That I've already heard some discussion amongst some employees, and that has to do with probably like the one that you saw about the incremental vacation time, for example. So after year 1, up until year 10, you have the same amount of 80 hours per year that you accrue. Under this, you start accruing an additional 8 hours from year 6 all the way up to 15. Mm-hmm. So that's a little bit of a different, that's an added bonus rather than wait till all the way up till you get to 10 years with the city before you get more than 80 hours of vacation time within a calendar year. So it's a positive step, but there may be people that have been here for, like myself, that's been here for 20 years. But, you know, it's the way it is. You move forward with the new policy. There are, I guess, some jurisdictions that, like I think we were talking today about, like the county that has got a different set of rules depending upon when you started. I think that becomes much more of a nightmare to try to administer that than just saying, nope, here's the new manual, here's how we're moving forward.
Starting day 1.
That's correct.
Councilman Sullentrop, the answer to, do the employees know about this? Yes. We have been speaking about it for 2 years. Employees know we've made changes. Department heads have brought employees' thoughts, ideas, concerns. Employees that have talked to all the department heads and said, well, I think this, or we think it should be that way. So by using our department heads' information from their employees that have said to Darren and I, hey, how's it going on that handbook? Where are we at on that tattoo policy? Have you figured out how to make sure that people stop coming to work sick just so they get their bonus days? You know, so-and-so came to work sick again because they didn't want to lose their bonus days. We don't think that's a good policy. Or how come I can't take a sick day for my kid while I'm out on FMLA and use my sick time? Things like that. So they have been bringing concerns to us over this process. And the word has gotten out, and then we use the department heads to help us filter some of that back through, get information, make sure it was applicable to employees in every position. We can't make it, not every employee is the same, but we're trying to make it as equitable as possible.
And we've had discussions about it at our lunches as well,
Yeah.
at our birthday
Oh,
lunches.
Your mayor's lunches, yeah. It's been the topic at most every gathering that we've had.
Yeah, they're anxious to see how it works out.
Thanks for all your work.
Long overdue, nice job. Anxious to see it.
So you all will get your copy and then review it, and then I guess let Darren know, or Shauna, if you have any questions, or how shall we do this?
Can we have the questions in an email format? And that way we can make sure we can run it through legal counsel as well if it's something that we don't know the answer to.
Correct. That would be good.
We give it to him on paper.
And then I guess depending.
Mark can call me if he has a question.
Transcribe it.
Any council member that feels like you want to call, that's fine too.
Shauna, are you asking that we email you with those comments or through Darren? I mean, how do you want us to proceed?
I would prefer to probably go through Shauna.
I bet you would.
And I say that because I don't want it to get lost in my 60 emails I get a day, so.
So changes, questions, concerns can be emailed to me. I will send them on to Christy.
And then depending on what we hear, we'll decide if it should be on the first meeting or the second.
Right, we'll either bring it to you and, as a possible, it could be another question if we have at the workshop on December the 6th with an ordinance to follow later that evening, or if we feel that we've got a lot of questions about some other stuff that we need to cover, we'll try to cover it on the 6th and then go bring it back to you on the 20th.
Okay, is that everything? Because then we can go sign that stuff.
Yeah, that's it.
Okay. Okay,
questions?
are there any other questions or comments? We'll entertain a motion to adjourn.
So move.
Second.
Okay, we have a motion by Sullentrup, seconded by Pettit, to adjourn the workshop. All those in favor signify by saying aye.
Aye.
Opposed? By your vote, we are adjourned. Thank you. And maybe.
Yeah.
Date? Okay.
Oh, here's some of them.
Mike Grimm?
I just thought it was so weird that he lived
Did you? Yeah, me too.
He worked at this pretty good.
It's like he says too, if you want to scribble on it and stuff, you know.
Mrs. Jones.
We should have like a toll clock. Hey, Ray.
The Graduate was on TV.
Let's go ahead and call the meeting to order, please.
Regular meeting of Washington, Missouri City Council, Monday, November 15th, 2021, 7 p.m. Heidrich?
Here.
Holtmeyer?
Here.
Patke?
Here.
Pettit?
Here.
Reed?
Hello. Yeah, here.
Scornia?
Don't hear very well.
Sullentrup?
Here.
Wessels? Here. Please rise for the Pledge of Allegiance. Will all the council members answer if they have or have not read the minutes of the council meeting dated November 1st, 2021? Heidrich?
Aye.
Holtmeyer?
Aye.
Patke?
Yes.
Pettit?
Aye.
Reed?
Yes.
Scornia?
Yes.
Sullentrup? Wessels?
Having read the minutes, are there any comments or questions?
Motion.
Second.
We have a motion by Sullentrup, seconded by Heidrich, to approve the minutes from our last meeting dated November 1, 2021. All those in favor signify by saying aye.
Aye.
Opposed? By your vote, you approve the minutes. Thank you.
Approval and adjustment of agenda, including consent agenda. You have a liquor license application for BAPS West End LLC.
Are there any questions regarding the item on the consent agenda?
Make a motion.
Second.
We have a motion by Holtmeyer, seconded by Pettit, to approve the items on the consent agenda. All those in favor signify by saying aye.
Aye.
Opposed? By your vote, you approve the item. Thank you.
Priority items, mayor's presentations, appointments and reappointments, police department reappointments.
In your packet, you will find information for reappointments to the police department. Chief?
Yes. You have Officer Benjamin Cassett, Sergeant Mike Grissom, and Detective Michael Wisbaum. Officer Cassett is developed into a fantastic officer. Sergeant Mike Grissom, you have sitting back here.
There he is. Hey.
And Detective Michael Wisbaum. And recently, we had that robbery on Caroline Drive, and 2 individuals, suspects were involved in that. He followed up, obtained the information necessary, did a search warrant, and arrested the second subject, and got a confession out of him, just to let you know his kind of.
Good job. Very good.
So I would request that you reappoint these officers.
Are there any questions or comments?
Make a motion.
Second.
Okay, we have a motion by Heidrich, seconded by Patke, to approve the reappointments of Police Officer Benjamin Cassett, Sergeant Michael Grissom, and Detective Michael Wisbaum. All of those are for a 1-year term.
Yes, 1-year term.
All those in favor signify by saying aye.
Aye.
Opposed? By your vote, you approve the reappointments. Thank you.
Council.
Thank you, Mr. Grissom, for being present also.
Public hearings, rezoning 600 West Front and 539 West 2nd Street. This item has been tabled, and I just need a motion to accept that.
Make a motion.
Second.
Okay, we have a motion by Heidrich, seconded by Pettit, to table item 3A. All those in favor signify by saying aye.
Aye.
Opposed? By your vote, you tabled that item. Thank you.
And I'm still reading the ordinance, correct? Okay. An ordinance amending sections 400.100A and 400.100D of the Code of the City of Washington, Missouri.
Holtmeyer.
Introduced by Councilman Holtmeyer.
Good evening. This is a code amendment, proposed code amendment for the revised C3 district. downtown. There's two changes in here, and A, on the intent and purpose of the downtown district, we've added that last sentence to say the intent of this district is to set potential growth boundaries for the historic district and to allow for mixed uses and higher densities that are appropriate for the area and to be considered downtown Washington. We wanted to be clear that the revised district was actually setting growth boundaries and determining an area, because beforehand, someone on the other side of town could have asked for C3 with really no intent in the code to say why it wasn't appropriate, and now we have that designation to say, no, this zoning is meant and the intent of it is for downtown. And then the second change is, after discussions with the Planning and Zoning Commission and the Fire Department, there is now a special use, so any proposed zero lot line on a parcel that is on a four-way intersection has to have a special review and a special use permit to make sure there's no site triangle issues. A good example was at Main and Market. Those buildings went up because they had zero lot line, and then reactively we had to bring it back to traffic and put stop signs in. And so we'd like to proactively be able to review that beforehand to determine is...
That's not a four-way.
Yeah, it is.
It is now.
It is now.
It is now.
Oh, Market. Okay.
Yeah, Main and Market, yep.
Okay,
Yep.
sorry.
So,
Is now.
yep. So those are the two changes in this ordinance. And Planning and Zoning did vote on this last week unanimously to approve these changes.
Okay, any questions or comments?
All right, thank you.
This is a public hearing, so open it up for
Right.
comment.
So is there anyone here who would like to address the council on this issue? It's a public hearing. Okay.
An ordinance amending sections 400.100A and 400.100D of the Code of the City of Washington, Missouri. Heidrich?
Aye.
Scornia?
Yes.
Patke?
Yes.
Holtmeyer?
Aye.
Pettit?
Aye.
Reed?
Yes.
Solentrop?
Yes.
Wessels?
By your vote, you approve the ordinance. Thank you.
Citizens' comments?
Is there anyone here who would like to address the council on any item that is not on the agenda?
Ward 2 is waving at me.
Please come up to the
Please come to the
microphone. And just for the record, you'll need to state your name and your address.
My name is Ken Washburn, at 2784 Stonecrest Drive here in Washington.
Okay?
And the issue is a project that's been going on for many years on South Point Road. And the two board members have just today received the information about it. Do you want to present it, or? No?
Wait, all I got this, Ken, all I got was this right here.
Okay, but you got the attachment? There's a project going on South Point Road, down toward, right across from Rikers and the Presbyterian Church. And the ward members have a photograph of the property.
Yeah, we all have that photograph
you
now.
do have that?
We received
They
that email
shared it
today,
with,
so-
Oh, you all have that, okay.
Yeah, we all have that. We received
Okay.
that. It was here.
I guess our question is, as residents, and we're talking about the residents of South Point Road, of Stonecrest, of many different entities, it seems like nothing's happening there. And the initial report was to all of us that there was planned to be a firehouse there. Is that true, or at least in the planning stuff?
Are you referring to the site that's been graded or the site that is not? Because there is a private developer that owns the 28 acres that's adjacent to South Point Road. He owns he owns the majority of the road frontage along there, especially based on your exhibits where the pieces of equipment are sitting.
Yes.
Those are all, the only thing, I'm not aware of any proposed use that they have given to us in terms of a building permit. They were trying to get the pads ready for commercial use, but I'm not familiar with any type of permits that we've been, in terms of building permits that they have been issued. With regards to a firehouse, the city does own 2 acres that are just, as a matter of fact, the portion that you see right here that's uncut, that's
within
sitting
that-
higher. Yes, that's the portion that's not been graded. The city is still looking at that, at the possibility of a future firehouse. We own those 2 acres, but the rest of this is privately owned.
Then the second item that had been mentioned, some type of a water retention facility up at the very top? Some type of a tank?
There was, at one point, there was also a look for a water tower. That was the reason,
Yeah.
another reason why the city kept 2 acres under their title for that. We have since found another site that we want to go ahead and locate the water tower. That has been at the corner of North Goods Mill and South Point Road, which is further south than
Okay.
this site. So right now, the only thing that the city's only looking at for the 2 acres would possibly be, is for the firehouse,
Okay.
possibly.
If I can just, I think one of Ken's concerns is, I'm looking at these papers, is there any kind of a time frame for the developer? I think what he's saying is that equipment's been sitting there for some time and it's been great. And it looks like nothing has happened for some time. Is there any kind of requirement that, okay, within a certain period of time, within city limits, you have to, is there anything like that?
Short answer is no. I mean, this situation occurs in the Phoenix Center. There's equipment sitting on empty lots in Phoenix Center. There's equipment sitting on empty lots on High Street. I mean, when you get, they have a grading permit, but the grading permit, I don't think has a specific timeline on when to, essentially plant grass or those type of things. So it's somewhat under development, maybe would be the best way to say it. They do have a land disturbance permit from the Missouri Department of Natural Resources and those things. But again, there's no timelines that ever really get put on those.
Does the permit have to be renewed?
With the city? No. We don't have a renewal process. At any given time, the city engineer can require them to update the permit, but I've not done so at this time.
There's no time frame on that?
No.
So this, I don't know what, you seem quite familiar with this.
I know where the property's at,
Yeah, I
yes.
know where it is.
Better.
Yeah,
Yeah, I better.
Or you all do?
yeah, we all know where it is.
Are you tired of looking at it too? I don't know. But anyway, is there some time frame that, a developer has to either develop or get off?
No,
I would say
the
it's in the
developer
process of
owns the
development.
property. The developer owns the
He's
property.
the
He is the
owner
owner of the property. So it would be hard to chase him off his own property.
I mean,
would think.
there's other restrictions as far as mowing grass within 200 foot of a residence, but there are no residents in that area there's no residential area that is in city limits adjacent to that property.
Right.
So I can't think of any, unless maybe across the road. I'd have to check on that. But there are, some potential there. It would be hesitant. It's under development. I mean, that's the thing.
under development.
I know it's taken some time and
I think the other thing is, apparently the developer has been, he's had fences and so on to keep stuff off the road. We haven't had, other than when they were going in and out briefly, we haven't had mud on the road or stacked up or anything like that. And that would be something that the city could take some action on.
very different situation.
Yes, right. But that, at this point anyway, doesn't seem to be the case, so he can take his time.
When he came before the city originally, he had supposedly a buyer for it, and this was going to be this, and it was going to be that. Evidently, that's why it's for sale. That sale fell through. He can't grade it because he doesn't know what to grade it for.
Well, yeah, that's just it. And the grading has been completed for probably the better part of the year. And the machinery's still sitting there. And everybody's driving by and looking at it. I think one of the reasons we love living in Washington, and we've lived in a lot of places over the years corporately, is that, there's good control of the city. And it's appealing to people, it's appealing to the residents. Things like this just somehow they don't fit in the picture. So I'm just passing this on. You all have your agendas and decide what to do. But this particular owner is also the developer of where we live in Stonecrest. Is that correct? We have to enforce him to mow his properties that are in Stonecrest. We actually have to you know, give some legal submission to have you mow your own property and to get equipment off of it. And he had an open sewer well there for several years, and children were playing in that open space there. And, you know, things like this just somehow, they don't fit the profile of Washington that we feel.
Okay,
So enough said. I
right.
think you know where we're going.
okay.
You
Thank
guys.
you.
All right, well, thank you for being here.
Okay,
Uh-huh.
thank you.
John, do you have anything?
Well, is there anyone else with citizens discussion? Okay.
Report of department heads?
Yeah, just a quick update on the Fair Street project. The mill was mobilized late last week, the asphalt mill. They should be starting that milling operation hopefully tomorrow. Weather holds out, paving towards the end of the week, so that'll get Fair Street somewhat buttoned up for winter time. There'll be ongoing grading, we do believe, with that, and some retaining wall work. The contractor's also mobilized over to the International Shoe Factory, replacing those sidewalks as well as part of that project. If you recall, we kind of broke that up into a phase 1 and phase 2 to orderly get us into wintertime and then work through wintertime in somewhat of an orderly fashion. And so far, that's working in our favor.
Who's doing the work around the shoe factory?
It is Gershenson Construction is the general contractor.
Okay.
And I believe they hired Sweetens out of, I think, Wentzville,
Okay.
Concrete as their sub.
They're going to try to get that.
Yeah, that's got to get, they have a deadline of basically Thanksgiving to get that
Okay.
done.
All right.
So it's moving.
Oh, yeah.
They did demo.
I've seen they got it all
I did
out.
see some forms were up today.
Yeah.
So, so far, indications are they'll meet that.
That's great.
John, just a quick note.
Yes, sir.
I know I spoke to you about this before, but hopefully that Fair Street won't turn out like High Street did with the waves going through the asphalt.
Yeah, I don't see any issues with that, yeah.
Okay.
And then we also have, with Fair Street, I'm trying to think, where was I going with that? Like I said, the second phase, you know, they'll be doing wintertime construction essentially right here on 4th Street with concrete work. And like I said, it's a very orderly, tear-outs have to be replaced within 7 days, those type of things. So we'll be kind of keeping a close eye on that, try to keep that moving.
Cool. Thank you.
Yes, sir.
Is there anyone else, department heads? Okay.
Ordinance Resolutions, an ordinance accepting the bid from Clark Equipment Company, doing business as Bobcat Company, Government Sales, West Fargo, North Dakota, and to approve the purchase of a 2022 14-inch planter, standard flow, by the City of Washington, Missouri.
Holtmeyer.
Introduced by Councilman Holtmeyer.
Good evening,
Tony?
Council. What this is basically is a new miller for our Bobcat skid steer. The technical name is a planer, but we all refer to it as a miller. So the one we have is a 2005 model. It's had some mechanical issues this year. We've put some new parts on it, so we are going to keep it around for a backup, but this is just going to be a replacement for it eventually. We did buy it off the state bid pricing, but we did get 3 quotes to go with it, just for.
Any questions or
That's the
comments?
reason for the discrepancy in the pricing is because of state bid?
I do not know that for certain.
Okay.
Because I think when we
Substantially
initially.
different from the 3, that's what I'm saying.
Yeah, when we initially talked to Bobcat, they were like, oh yeah, we'll bid it off the state bid. We can try to get a better price that way, and the other 3 did not bring that up.
Okay.
Any other questions or comments?
All right, thank you.
Thank you, Tony.
An ordinance accepting the bid from Clark Equipment Company, doing business as Bobcat Company, Government Sales, West Fargo, North Dakota, and to approve the purchase of a 2022 14-inch planter, standard flow, by the City of Washington, Missouri. Hydrich.
Aye.
Scornia.
Aye.
Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Aye.
Reed.
Yes.
Solentrup. Wessels.
By your vote, you approve the ordinance. Thank you.
An ordinance amending section 300.010, repealing sections 340.110, 340.115, 340.117, and 340.120, and enacting a new section 304.110 of the Code of the City of Washington, Missouri.
Holtmeyer.
Introduced by Councilman Holtmeyer.
Council, this is refinement of ordinance pertaining to golf carts, ATVs, UTVs, all-terrain vehicles, off-road vehicles. Reference to all the different types and classifications, and has taken several different ordinances and combined them and put more along the rules along the same thing for everything. Sergeant Grissom worked hard on this. So I am going to let him come up and answer any questions you have and take care of it with you. So,
How soon do they have to have these permit if this is passed?
they are permitting now. We've been permitting them for a couple months now.
Oh, okay.
This has been a little bit of work in progress for Traffic Committee for several months now. Previously, we had a mechanism in city code that required us to issue permits to UTVs and recreational off-highway vehicles if they were going to operate in the city. We've always allowed them to operate, but we've never had a mechanism to issue permits. So we did go ahead and do that so that we were at least in compliance with our current code. What we ran into was we had, and you'll see all these code sections we're repealing. That's because all of these different types of vehicles were covered under different sections of code, and they all had different rules. It was super, super confusing, and frankly, it was just a mess. So ultimately, Traffic Committee and Mark Piontek and I kind of got together, and the goal was to include all of these vehicles under one umbrella, under the same code with generally the same set of rules, so it would be less confusing. Under that new code, it does kind of give us some more options for permitting also. We were issuing permits to individuals, so if a married couple has a UTV, they were having to pay a separate fee each, and then they were issued a permit. Under the new code, we'll just issue one per vehicle, and they'll get stickers. It should be a whole lot easier and just less cumbersome for everybody involved. So,
Mike, is that going to be like we talked, like a reflectable type sticker they can put on the back? So if you guys are driving behind them at night, you guys it'll reflect.
So the sticker I currently have approved for, it's not reflective. However, it's orange. And it's going to be obvious to see. They will be required to display them on the vehicle while they're operating it. There really wasn't a good way to tell them exactly where they had to display that because we have different types of vehicles here. So the requirement is that they display it. That can be anywhere as long as it's visible. So that probably isn't ideal, but that's what we have to work with.
That's going to work better in those permits.
Yeah.
And I like the idea of per vehicle.
Yeah.
Not 4 different.
Correct. It's a $15 permit fee. Our interest was never to make money off of this thing, and we found that there were people paying for 3 or 4 permits for one vehicle, and that was a little bit excessive. So,
Mike, what are they required to have to get a permit?
So currently, when they come up, they provide us with proof of liability insurance on the vehicle. We make sure the person has a valid driver's license, and then they fill out the permit application, basically.
Like
after that,
the big orange triangle, do you have to have that on there, or they have to have a flag hanging off of it?
No, the slow-moving vehicle triangle's not a requirement. Neither is a flag. A lot of this comes from state statute. There's statutory definitions for all these types of vehicles that already has some kind of rules. So we were careful to try to make our code work with state statute so we don't have contradictions there. And we didn't want to overcomplicate it either.
I'm sorry. I know the golf carts are allowed on this. What about evening travel?
Anything operating in the evening time will have to have lighted lamps similar to a vehicle. Brake lights, headlights, tail lights, headlights, that kind of thing.
Okay.
That was my question, yeah.
Okay, so no triangle is required. Permit is required through the police station, correct?
Correct.
Not the license office, but police station.
Correct. Station.
And we have a VIN number included on the permit?
The permit will have a number, a unique number issued to it that we can then relate back to their permit application. So we will know who that permit is supposed to belong to.
Okay. Obviously the side-by-sides are it, the golf carts are it, four-wheelers, so straddle seat, those are included also?
They are not.
They are not?
This code prohibits ATVs, and an
Okay.
ATV is defined as something that you straddle
Right.
and steer with handlebars. We will not be issuing permits for ATVs with this code as it's written.
So we're talking side-by-sides and golf carts?
Yep.
And they're under the same umbrella?
So an ATV cannot operate on the roadways in the city.
Okay, that's
I don't know how it goes towards farm equipment and classification in that manner, but
Well, in reading the past ones, that's how it was allowed, was if it was a farm.
Missouri law gives a lot of leeway to farmers.
There still are statutory exemptions for agricultural use for a lot of these things.
Okay. Answers a lot of questions. I know a lot of people have been asking me.
Yeah.
The main thing is that they have to have insurance.
It's
No one's
confusing.
against it, as long as the guy next to me has insurance, that's what we're looking for.
Right. The statutory definitions for them are super similar, but just different with some little subtleties here and there, so it makes it really confusing. But we can't change that. We have to work with statutory definitions, so.
You mentioned agriculture, they're gonna have to have a permit also?
I believe the statutory agricultural exemption so if you have a mule that you need to drive into town to ZX to put fuel on from Bluff Road or something, I believe that they would be exempt if Mark agrees with that.
I think so, yes.
I think they're also limited in nighttime operations for agricultural. They cannot do that at night, right? Is that right?
They can operate any of these at nighttime as long as they have headlights, taillights.
Okay, so agricultural
brake lights,
could
turn
too,
signals.
as long as they have the lighting.
What's-
Agricultural too, as
Yeah.
long as they have the lighting.
Yes.
So, Mark, just to reiterate, you said headlights, taillights, brake lights, and
Headlights,
signals.
taillights, brake lights, and turn signals.
But if you don't have those, you can operate during the day.
Daytime only.
Gotcha, right.
And by statute, so it's in our code, utility vehicles and these recreational off-highway vehicles have to have seatbelts.
Say that again, utility vehicles?
And recreation, so utility vehicles,
UTV side by
see these
side.
things, they'll have, sometimes they'll have a dump bed or something
Yeah.
on the back.
Yeah.
And then
Like a
these
gator.
side-by-sides, if you're gonna run them on the city streets, they have to have seatbelts.
If you can picture a Razor, the sportier looking ones, those meet the definition of a recreational off-highway vehicle, whereas a mule or a gator is a utility vehicle. They're really the same thing for all intents and purposes, but the state law defines them differently, so.
I was asked by an individual, are they legal to drive on a numbered highway and not lettered highway, or is it the opposite?
So the state statute only allows you to operate ROHVs, recreational off-highway vehicles, on state highways within 3 miles of your residence. So if you live in the county, you can drive a ROHV around within 3 miles of your residence. It doesn't, the statute doesn't specify if it has to be a lettered road or a numbered road or anything like that.
Okay.
Any other questions?
Well, people have asked that question, if we're only doing city streets, how are they not allowed on number streets, so how are they on Highway 100? So if you see a UTV on Highway 100, is that a red flag, or is that a?
Under the current code, it'd be unlawful to operate them along a state highway within the city limits.
Under the code we're doing right here, or the?
Correct, yes.
Yeah.
The updated code.
No operator of a utility vehicle, recreational off-highway vehicle, or golf cart shall operate the same on any federal or state highway.
You can cross it, you can't operate on it.
Correct. As long as the posted speed limit on that highway is less than 45 miles, or it's 45 or more.
And can I confirm, so state law actually allows them and we just are regulating within the city limits? Is that, and the reason I ask is, I mean, I don't have a golf cart. I'm like, why would I drive a golf cart instead of a vehicle? And so I guess I'm trying to understand the purpose of them.
Specifically for ROHV, state law allows them, as long as the city allows them, essentially, to put it as simply as possible.
So the city could disallow it?
Correct,
Okay,
yes.
that's what I was trying to understand.
So, Mike, all these vehicles need taillights and such for dark, at night. But scooters can cruise all over with no taillights.
They have tiny little taillights.
Scooters have taillights.
They have a taillight.
And a bicycle.
What taillight is it?
And a bicycle,
Taillight.
a bicycle is required if nighttime operation to have a headlamp and reflectors.
Yeah.
Scooters have headlights and taillights. You can see them.
Even a bicycle has to have a headlamp and reflectors if it's going to operate at night. It can't have, we've stopped one recently that had nothing on it. That was dark.
I just been told you can't see a taillight on the back of a scooter. I don't know. I've never ran up on one at night, so I don't know.
Well, I think for bicycles, it's reflective. It doesn't have to be a light,
Right.
it's reflective.
Right.
I know it's a lot. Any more questions?
No, I think that it was a situation that had to be dealt with. I appreciate, it seems like it's a little bit redundant on some aspects, but I think was done right, so thank you.
Thank you, Mike. Anything else?
2 more weeks and you got to shave.
Only, they can, they can keep going if they contribute to the All Abilities Athletes Fund. They can go for a little bit more, so.
Good night, thank you.
An ordinance amending section 300.010, repealing sections 340.110, 340.115, 340.117, and 340.120, and enacting a new section 304.110 of the Code of the City of Washington, Missouri. Hydrich.
Aye.
Yes.
Scornia. Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Yes.
Reed.
Yes.
Solentrup. Wessels.
By your vote, you approve the ordinance. Thank you.
Chief, Sherry, can I ask one? Chief, if someone does have a complaint or neighbor doesn't have a sticker, they can call the police department?
Yes.
As report?
Yes.
Thank you.
An ordinance authorizing payment to the Industrial Development Authority of Washington, Missouri, and the Washington Civic Industrial Corporation, and amend the 2021 budget.
Introduced by Councilman Holtzmeyer.
This follows up on the letter that I gave you in the workshop a couple of weeks ago, I think. It's like back in October 28th. This basically repays back the Industrial Development Authority and Washington Civic Industrial Corporation. If you'll recall, during COVID, the Chamber had requested from the city to relieve them of their obligations, or at least a part of their agreement that they have with us, to help pay towards the salary of the Economic Development Director. And so in order to chip in, both of these groups decided to go ahead and pay the city for that, for what the Chamber couldn't at the time. And so they also asked then that once we had received ARPA funds the last spring, or once we knew we were going to receive those, we wanted to go ahead and pay both of these entities back because it qualified under the ARPA Act. So this pays both of those entities back for their contribution.
That amount was 2.4.
Oh, of what we received through ARPA funds, it's 2.5 plus. It's a little shy of 2.6 million.
Any questions or comments?
An ordinance authorizing payment to the Industrial Development Authority of Washington, Missouri, and the Washington Civic Industrial Corporation, and amend the 2021 budget. Hydrich.
Aye.
Scornia.
Yes.
Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Aye.
Reed.
Yep.
Solentrup.
Yes.
Wessels.
By your vote, you approve the ordinance. Thank you.
An ordinance authorizing the City of Washington, Missouri to issue its taxable industrial revenue bonds, WEG Transformers USA LLC project, Series 2021, in a principal amount not to exceed $29 million for the purpose of providing funds to pay the cost of acquiring, constructing, and equipping facilities for an industrial development project in the city, approving a plan for the project, and authorizing the city to enter into certain agreements and take certain other actions in connection with the issuance of the bonds.
Solentrup.
Introduced by Councilman Solentrup.
Yes, good evening. Thank you. This is a project we have been talking about for quite some time, and we're finally getting to the finish line with them. If any of you come to 353 meetings or WCIC, this was the Project Trace for a long time, and then we were able to announce that it was in conjunction with WEG purchasing the Melton building and also doing an expansion at their Avantha Drive project. And so we have worked out with Gilmore Bell and WEG a Chapter 100 agreement for tax abatement, and I have outlined the basics of it in a letter for you, but just the overview is that it does include renovation of the new facility on Bluff Road totaling $15.5 million, a 25,000 square foot expansion at the Avantha Drive plant totaling $12.8 million, a commitment to a minimum of 40 new jobs at an average wage of $45,000 a year. And then the abatement program is a 50% abatement on the property tax at Bluff Road for 10 years, a 50% tax abatement on the incremental increase at Avantha. So they are setting a base at what they have now. The increment that goes up on the expansion, there'll be a 50% abatement on that, and then a personal property tax abatement of 50% on all equipment at both sites. Now, that I think the most important part to point out in here is that Gilmore Bell did a cost-benefit analysis of this for us, and as required before we approve any of these. And today, so say if the project were not to go forward, there would be, the two sites would yield $2.1 million in taxes over the next 2 years.
10 years.
I'm sorry, over the next 10 years, thank you, if the project were not to advance. If the project were to be completed, an estimated total of $4.1 million would be paid by the company over the next 10 years. With the pilot payments that they'll still be required to pay, you can see in there that second bolded number is WEG will still be making pilot payments over the next 10 years of just shy of $2.5 million. So their pilot payments actually exceed what would yield if the project weren't to go forward. And so that cost-benefit analysis, I think the city staff is very comfortable saying that that'll be, it shows it'll be a successful and worthwhile program to offer to WEG. We think this proves that the program works the way it is supposed to, that the taxing districts will still receive more than what they would have, and it incentivizes the company to invest in our community. So tonight, Stacy Schiermeyer with WEG is present if you have any questions for them, and as well as Mark Grimm with Gilmore Bell to discuss any details of the cost-benefit analysis or the program itself. So we're excited about the project. We want to congratulate WEG and thank them for continuing to invest in Washington.
Sal, a couple of things. One, your letter at the end was very helpful.
Right.
In terms of summarizing.
Yeah.
180 pages of fascinating reading. But I did have a question. Besides, I saw where the pilots, if they don't meet the job expectations, that there would be but there will be some pilots going on even if those are met. Is that correct?
Yeah, so if they meet the minimum 40 minimum wage, they still are, the pilot payment is the 50% that they would owe on it. So, and then that can, there's a...
I see. It's a penalty if they don't get the job. I got
Correct.
You.
Yep.
I got you.
So basically, the abatement goes down if they're not hitting the jobs.
Again, the last page is definitely helpful on summary, so thank you. How we got to those numbers where if the project doesn't advance and the number is better if it is, it's like, I mean, obviously it's a no-brainer, I get that, but that hasn't been true in all the other projects we've done. So what is the difference here that we haven't done in the past?
Well, I think it really helps that they are, with it being two sites, they're not asking for full property tax abatement on both sites. It's the incremental on Avantha only,
okay,
which helps them kind of close that gap, actually exceed that gap of their pilot payments exceeding what would come in anyway. So, I mean, that is ideal. You're right, that doesn't always happen just because sometimes if it's a, Melton built on a farm, obviously the existing, there wasn't any taxes there. And so that's impossible to meet. In this case, these are existing properties that they're renovating or expanding on. And so they're able to utilize the program to grow and then still pay the pilot payments. So.
Any other questions or comments?
The site that they're expanding, is that the old Melton building?
No. So they're renovating the old Melton building on Bluff Road, and they're expanding off of Avantha Drive behind LMI.
Okay.
I started to read this on Sunday night, and I had to make a decision after the fourth page to watch Yellowstone or finish reading this. So I'm sorry to say I have to go on the counselor's approval on this because I'm sure he read every page. Is that true?
For those, for those who may not know what we're talking, let me read you part of this is just part of one sentence in the 180 pages. Every successor trustee appointed hereunder shall execute, acknowledge, and deliver to its predecessor, and also to the city and company, an instrument in writing, accepting such appointment hereunder, and thereupon such successor shall, without any further act, deed, or conveyance, become fully vested. And this sentence goes on about 3 times what I just read. I mean.
All I can say is Gesundheit.
Gesundheit.
You wrote it.
Yeah.
Boy, you wrote it.
As Mr. Piontek told me earlier, he said that's what we learn in law school. Why say something in 5 words if you can use 500? Good stuff, though.
Yeah, yeah.
This is good for us.
It is, yeah.
Good for the city. Did Stacy, do you have any comments or anything, or?
No, I mean,
Come on up.
To the mic, Stacy.
We're glad you're here tonight.
Oh.
Yeah.
Well, first, thank you. And second, I mean, we're anxious to get started as quick as possible on our expansion on our PT, our power building. But as you guys probably know, things take a lot longer now than they did a couple years ago. We had actually hoped to have the expansion finished by first quarter of 2022, and now it's probably steel just takes forever. Buildings, so now we're probably looking toward the end of 2022 before we get the whole power big business up and running. On the Melton site, we actually shipped our first transformers last week. So
Oh, good.
That business is operational, and we're still making some tweaks on it, but that building is, we've spent all that money, and we are now busily trying to ship transformers.
Trying.
Well, that's great. Well, it's so great that you were able to acquire the Melton building and that you're expanding here in Washington. I know that your corporate office is obviously in Brazil, and but
We have sister companies in Mexico, so we had to justify spending money in the U.S. versus spending it in Mexico.
And I know that it's just really cool that they have all agreed, and I know they've been here, and they are impressed with our community and like it here. I had the privilege to meeting, I can't remember his name, but anyway, it's really cool. And so thank you for all your efforts, because I know that you would have to really sell Washington to them, but I think we have a good product here. So thank you for your efforts.
I had the opportunity going through the building out there, and do you or do you not still use to haul the generator type transformers? Do you still use those great big trucks with that you can drive around mobile with the generators?
Yeah,
inside the building.
Yeah,
but you can drive them other places, right?
I think he's talking about the mobile transformers.
the
ones on
mobiles.
trailers.
Yeah, that was a kind of a one-time job, and we hope to never do it again. Because it's been a long process. It's successful, but it's very long.
Tracy mentioned the PT side and the Avanta building. I just know from being out there, they actually make power units, and I was showed one time that they have a setup outside that simulates lightning.
Yep.
Exactly what it does. It simulates lightning to whether the transformer can handle it or not, or what goes through there. It's pretty impressive. Those guys building insulators on top just to make it simulate that. And then at the other plant, I think at the old plant where the transformers come out, it's a steady line. As you would picture a car assembly line, it's the transformers just roll out continuously, painted, different sized. It's a pretty impressive business. So we're lucky to have them in Washington, and thank you.
All right, thank you.
All right, well, thanks.
Okay, you're welcome. Any other questions or comments?
Exciting.
An ordinance authorizing the City of Washington, Missouri to issue its taxable industrial revenue bonds, WEG Transformers USA LLC Project, Series 2021, in a principal amount not to exceed $29 million for the purpose of providing funds to pay the costs for acquiring, constructing, and equipping facilities for an industrial development project in the city, approving a plan for the project, and authorizing the city to enter into a certain agreements and take certain other actions in connection with the issuance of the bonds. Hydrich.
Aye.
Scornia.
Yes.
Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Abstain.
Reed.
Yes.
Sullentrup. Wessels.
By your vote, you approve the ordinance. Thank you.
An ordinance providing for the approval and acceptance of minimum improvements for maintenance for the Overlook at Weber Farms, Plat 6 Subdivision in the city of Washington, Franklin County, Missouri.
Holtmeyer.
Introduced by Councilman Holtmeyer.
The Overlook at Weber Farm, streets are in, water's in, sanitary sewer's in. It's been inspected. This would actually take those over for maintenance. There will be a 2-year maintenance period. There will be a bond in place as well for that 2-year maintenance period. And Tony can start snow plowing streets.
Okay. Just in time. Any questions or comments? Okay.
An ordinance providing for the approval and acceptance of minimum improvements for maintenance for the Overlook at Weber Farms, Plat 6 Subdivision in the city of Washington, Franklin County, Missouri. Hydrich.
Aye.
Scornia.
Yes.
Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Aye.
Reed. Yep. Sullentrup. Wessels.
By your vote, you approve the ordinance. Thank you.
Mayor's report.
I just wanted to announce that this Thursday is the Thanksgiving dinner. We usually do an annual
Luncheon.
Thanksgiving luncheon. It'll be here in the council chambers, so certainly if you all are in town, feel free to stop by. We're doing it in 2 shifts, so we aren't overloaded with too many folks in the council chambers at one time. So one serving is at 11, and the second is at noon.
I'll try to make both.
All right. So anyway, but it's always, the staff really enjoys it. So we're also doing carryouts.
I'm coming out.
That's all I have.
City Administrator's report.
No report. I do have 2 items for you in executive session.
Council comments.
Anybody?
City Attorney's report. Public vote on whether or not to hold a closed meeting to discuss personnel, legal, and real estate matters pursuant to Section 610.021 RSMO 2000. Hydrich.
Aye.
Scornia.
Yes.
Patke.
Yes.
Holtmeyer.
Aye.
Pettit.
Aye.
Reed.
Yep.
Sullentrup. Wessels.
Aye.